The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your socially distanced podcast on the Federal Courts of Appeals. If the audio is not up to the standards you expect, that's because we are all sequestered and meeting via Zoom. But this week we've got an exciting show with cert petitions, shankings, and smart mouths. Joining me are Patrick Giacomo and Adam Shelton. Patrick, take it away.
Thanks, Paul. So speaking of cert petitions, IJ had two that were considered by the Supreme Court last Friday during its conference. We have some good news and some bad news. I'll start with the bad news. Our cert petition in the case called Carousel Farms was denied. That was an eminent domain case where the Colorado Supreme Court permitted a developer to form a quasi-governmental entity and then use eminent domain to take its competitor's property so that it could build a development that it would then annex into a town in Colorado.
Pretty remarkable case from what I understand. So you've got a private entity that is empowered to create its own government entity that has the power of eminent domain.
That's right, and it's even stranger than that because quasi ownership interests are enough to give you a voting stake in the eminent domain. And so what you basically do is if you lived in a house with your wife and your neighbor was a single person, you could create a quasi-governmental district that encompassed both of your properties, and then you and your wife could vote to take your neighbor's house. And in Colorado, that's totally fine.
And the Supreme Court took a pass on it this time. Hopefully we'll be able to get that issue back up before them.
Yeah, it's interesting because essentially what the issue that Carousel Farms raises has to do with this public use concept that came out of Kelo, where the Supreme Court decided for the first time that economic development was sufficient for a Fifth Amendment taking. And a lot of what the court said, both in the majority and then in concurring opinions, had to do with explaining that, of course, you wouldn't allow anything that would be a pretextual taking where you're essentially just allowing the power of eminent domain to be used to benefit a single private party or special private interests. And obviously that's exactly what happened here. And so this case is one side of a split where a number of state courts have said, like the state of Colorado, that if there's an asserted public use, so if they're taking this property and they're telling us they're doing it to build something like a road, then we're not going to question that. We're going to defer to that, and that's good enough for us to approve the taking under the Fifth Amendment or whatever our state corollary is. And then on the other side of the split, you've had states like Hawaii that have said, actually, under some circumstances, we're going to look beneath that and see if there actually was a pretextual taking and decide from there whether it was an appropriate public use.
Yes, so a lot of people may not remember, but in the Kelo case, one of the things that was in Stevens's opinion was this discussion of how well planned the whole economic development scheme was. So maybe some courts are looking to that and deciding, we actually have to see, is this part of a real plan or is this just part of a giveaway?
Yeah, that's true. And both the majority and more strongly Justice Kennedy's concurrence very specifically spoke to situations where the taking, like something that happened in Kelo, where that was a pretext, the court would look beyond that and say that that would not be something that would be appropriate under the Constitution. But as of right now, the Supreme Court's apparently not interested in taking up that issue and deciding it. And so we'll just have to keep trying because I think it's pretty important. And you can see cases like this or Texas cases, for instance, where they've taken private land to basically create a driveway for a bank. And the Texas Supreme Court signed off on that because that's a road. Those types of cases will probably start happening more and more often. And obviously the problem in the context of eminent domain is that a lot of the time it's just not worth economically the fight that you have to get a case like this all the way up to the U.S. Supreme Court.
Well, that's the bad news. What's the good news?
So the tentatively good news is that one of our other cases, which is called Brownback versus King, was relisted from Friday's conference last week to this week, which means it wasn't denied, which in the world of Supreme Court statistics, no news is good news. And we'll see what the court does going forward. But at least it was not among the 200 plus cases that the court denied on its Monday morning order list. And that case,
tell us a little bit about that.
Yes, so that case is, we represent James King, who in 2014 was a 21-year-old college student who was walking between two summer jobs in Grand Rapids, Michigan, when he came upon two men who were dressed in jeans and t-shirts who started asking questions quickly, put him up against a car, took his wallet, at which point he tried to run. He was tackled, choked unconscious, and beat severely in the face and head. As he screamed for help for police, uniformed police finally showed up and then, to his surprise, arrested him because, as it turned out, the men who had stopped and beat him were plainclothes officers, one of whom was a Grand Rapids police detective and the other was an FBI agent, both working as part of a joint state-federal fugitive task force who were looking for a fugitive who was wanted for having broken into his boss's house to steal empty pop cans and liquor bottles. And the fugitive looked nothing like James King. And so that's kind of where things started. But James' case raises really interesting issues about the way that we deal with government accountability. And basically what happened here from the get-go was that the prosecutors and police basically created a shield around these officers and immediately took whatever action they could to make sure that those officers didn't face any sort of accountability. So, for example, one of the uniformed officers walked around the scene at where James was still being arrested and had people delete evidence, video and photo recordings of what had happened. James, instead of being released and apologized to for having just simply been misidentified, was actually arrested and charged with several felonies. The prosecutor then went ahead with the prosecution of those cases against James, offered him a plea deal, which he rejected, and he was ultimately acquitted by a jury of his peers, at which point he filed a civil lawsuit.
So just jumping in here real quick, people need to know how remarkable it is that he was willing to go to trial and risk conviction. Virtually all criminal charges in this country nowadays are solved by plea deals instead of by trials. And people who choose to go forward to trial often get overcharged. There's a huge disincentive to go to trial. So, good on him for having the guts to do that. But so he filed this civil lawsuit, and I'm guessing this is gonna be a qualified immunity situation.
That's right. And before I jump into that, I will say, yes, you're absolutely right. I think the high 90% of criminal cases in this country end up being resolved on a plea deal. So what James did was really remarkable. And the important piece here from a governmental accountability standpoint is usually in a case like James's, where you're dealing with Fourth Amendment violations. If the person gets convicted of the crimes, it's very difficult to bring a civil action against the officers because there'll be all sorts of conflicts related to whether there was probable cause or justified use of force. And so if James had taken that plea, and many people who do take those pleas, their chances of being able to bring a constitutional claim kind of evaporate along with the plea deal. And so, yes, in this case, James brought a number of claims against the FBI agent and the police detective, who were represented by the local U.S. Attorney's Office as federal officers working on this task force, which was administered by the Grand Rapids Police Department and the FBI. And as you alluded to, the government immediately argued for qualified immunity, which the district court granted almost summarily, kind of giving short shrift to James's account of the events and giving a lot of weight to what the officers said and kind of just waving the qualified immunity wand to get rid of the whole case. And so after the whole case was dismissed, we filed an appeal in the Sixth Circuit, which did something extremely rare in the qualified immunity world, which is overturn the qualified immunity decisions. And for those of you who aren't familiar with the doctrine of qualified immunity, it was created by the Supreme Court in 1982. And it basically says, if you're suing a government official for violating your constitutional rights, they can claim what's called qualified immunity. And then if you can't show that a court in your jurisdiction has already decided a case just like yours on what they call similar particularized facts, then the case gets dismissed because the officers are immune from any liability. So
And one of the really perverse things is that in recent years, what the Supreme Court has said is that when courts are looking at whether someone's constitutional rights have been violated and qualified immunity is asserted, they don't even have to determine whether the Constitution's been violated. They can just jump straight to qualified immunity. And so the result is that you end up with a lot of decisions saying, yes, this is unclear, so we're granting qualified immunity. And you never get the clarity from courts that you need so that future people can overcome the qualified immunity bar.
Yeah, that's exactly right. So when you have a claim of qualified immunity, you have to show that there was a constitutional violation and that violation was quote unquote clearly established, meaning that there was already a decision saying that what happened was unconstitutional. And Paul, you're totally right. Not too long ago, the Supreme Court changed the analysis and said you can skip the question of whether there's actually a constitutional violation because you can assume without deciding if there is and say, well, there's actually no court case that decided that this was a violation. And so we're not going to decide it here, but qualified immunity protects the officers.
So what is the question presented by the cert petition?
So like I said, thankfully the Sixth Circuit reversed the qualified immunity decision. So now on the cert petition, the issue isn't even involving qualified immunity. What happened was the U.S. Solicitor General has now petitioned the Supreme Court for cert on an issue underneath a special statute called the Federal Tort Claims Act. And to spare everyone the technicalities of it, essentially what the Solicitor General is asking the Supreme Court to do is to create a new species of immunity that would protect government officials in a different way and bar constitutional claims like James's. And so we've defended against that petition, but also filed our own cross petition because one of the other things that the Sixth Circuit decided was that these two members of this joint state federal task force are to be considered federal actors instead of state actors, which changes the entire analysis and a bunch of other things related to how successfully you can pursue constitutional violations. And so basically the big picture that we're asking the Supreme Court to consider is whether it should add or subtract accountability from the equation when we're dealing with a situation where a government official has violated someone's constitutional rights.
Great. And so you said the Supreme Court has relisted the case. So for those who aren't familiar with Supreme Court practice, as Patrick said, normally, at least initially, no news is good news. And what they have been doing for the last few years is if they see a petition and they think it's interesting, they won't grant it after the first hearing. They will relist it at least once, to kind of check it out procedurally and kick the tires and make sure it's a good vehicle. No way to know if they're doing that with this petition, but at least we know they haven't rejected it outright.
Yeah, and it's a very anxious morning for anyone who has a petition pending in the Supreme Court waiting for the orders list to come out and then frantically reading through it to see if your case is on the list. So we'll see what happens. Statistically, no case has a particularly good chance of ever being decided by the Supreme Court, but where the Solicitor General's on one side of the V and where the court has relisted the case, your chances are statistically a lot better than they otherwise would be.
Mm-hmm. That's great. And so there's one more case we've been involved with up there recently, this time as amici and not as representative of one of the parties. Can you tell us about the Jessup case?
Yes. So the Jessup case is a case out of the Ninth Circuit where the background story there is there were two businessmen in California who ran an ATM business who were suspected of also running an illegal slot machine business. And so police in Fresno, California executed a search warrant related to that investigation. Ultimately, neither man was ever charged with a crime. But what happened was the police took $275,000 in cash and rare coins. And these men had this cash because of this ATM business. But the police only recorded $50,000 in their evidence logs. So basically $225,000 worth of currency went missing, meaning that the police kept it. And
was that wrong? Should they not have done that?
I mean, I think that it's a fairly generally accepted concept that stealing anything, let alone $200,000 from someone is morally repugnant no matter what time period or culture you're living in, which makes it a somewhat unique as far as universally reviled things to do. But notwithstanding that, when the two men sued the officers for violating their constitutional rights when they stole this money, the district court and then the Ninth Circuit both said, actually, these officers were entitled to qualified immunity because, as Paul alluded to, it wasn't clearly established, meaning there wasn't a case that had already specifically told these officers that you can't steal someone's money from their home, which it really stretches the concept of clearly established law to its absurdest possible point, where you say, look, any 5-year-old knows you can't steal from people. So you'd think the people that are enforcing the laws of all people would be aware of this general precept and not need some sort of on-point court decision to tell them that what they did was against the law.
Yeah, it's truly perverse when you think about it, because the most egregious violations of constitutional rights are the ones that you don't expect to happen in the first place. You never expect that the cops are going to steal $225,000 from someone. And so you don't have a lot of decisions out there considering whether cops are allowed to steal money.
Right. And that's been across the board. One of the problems that has been pointed out about qualified immunity is that the more outrageous your behavior, whether it's stealing, killing, maiming, lying, whatever, the better chance you stand of not having clearly established law, which means the better chance you stand of having immunity. And so we filed an amicus brief asking the Supreme Court to take this case and address the entire doctrine of qualified immunity. And our brief kind of goes through the history from the founding up until present day. A lot of people, when they hear about qualified immunity, I don't think it really hits them until it has come to them several different times. But this is a doctrine that was created in 1982. And before that, it was totally anathema to the way that courts decided cases. From the founding until 1967, the Supreme Court basically applied a concept of strict liability to government officials who violated constitutional rights. They didn't carve any exceptions into the rule because they thought that their job was to decide cases and policy was for the legislature, and that included carving out exceptions or providing indemnities or things like that. And so the court would just decide whether someone's rights had been violated. The legislature would then step in and indemnify an officer if they had a money damages judgment against them. And that was the law from 1804 until 1967, where the court made its first exception. And then in 1982, it threw out the whole regime and in its place put qualified immunity.
So, I think one of the interesting things we're seeing here is, for decades, maybe the more conservative members of the court have been seen as kind of tough on crime. But we're seeing this shift that sort of began with Scalia and his approach to the Sixth Amendment, and kind of a greater concern among the conservative members of the court for these sorts of procedural protections. So, is that part of what you think we're seeing here? Is this the right time for the court to be taking this case?
If you're reading the tea leaves, it certainly seems like it. I mean, it's interesting because the two most well-known critics of qualified immunity on the court are Justice Thomas and Justice Sotomayor. So it's definitely coming from both sides of the historic split of conservatives and liberals on the court. It's really a unique situation because everyone in the discussion kind of admits that qualified immunity is a totally ahistorical document that the court just came up with in the 80s, and we've kind of applied it and built on it since then. And it's just sort of become its own animal and grown in whatever direction it's grown in since then. But we know that at least 2 justices and probably more are critical of this doctrine. So we're hopeful that the court will take this case, and it's actually held a number of other cases that are up this year, and kind of everyone's hopeful that the court will take some or all of those cases and consolidate them and consider, what the doctrine should look like or what changes should be made to it.
All right. Well, that catches us up on what's going on at SCOTUS. Everyone, watch this space. We will keep you up to date as there are further developments. And now, without further ado, let's get into the cases from this week. So, Adam, please tell us about the shanking in West Virginia.
Well, thanks, Paul. So in this case, Mike Evans is an inmate at a federal correctional facility in West Virginia. And he happened to be stabbed in the back multiple times by another inmate wielding a Phillips head screwdriver in the prison dining hall. Because prisoners generally don't have access to any kind of screwdriver, He believed that the screwdriver was the property of the jail and that the jail officials had failed to properly secure the screwdriver after its last use. So he sued both the jail itself and the prison officials, and as part of his lawsuit, he filed a couple different Freedom of Information Act requests, looking for information both about the screwdriver and looking for access to the video of the actual incident. The Federal Bureau of Prisons, which handles all these requests, objected to both of them, on first arguing that the picture that Mike Evans attached to his FOIA request of the screwdriver, that all the jail officers looked at that and they said they didn't have the screwdriver like that, so they couldn't provide any information about it. As far as the video of the incident, they said that they didn't have the technology to separate out his particular instance from a lot of other lunchtime or dinner time events, and so that would create an unwarranted invasion of privacy for the other inmates. So the district court agreed with the Federal Bureau of Prisons here and said, yep, they don't have to provide the video, they don't have to provide any information about the particular screwdriver. He appealed to the Court of Appeals for the District of Columbia. They agreed with the district court about the screwdriver, about information about the screwdriver, saying, look, if they say they don't have the screwdriver, then they can't provide any information about it. But the video claim they were a bit more dubious about. There, the judge referenced teenagers using Snapchat to send pictures of themselves and replacing their own faces with cat faces, and being able to segment out their favorite parts of videos and send them to each other, or screenshot them and send them to each other. And he was
so the idea being that if teenagers can use Snapchat filters, then maybe the Bureau of Prisons can blur out the faces of the other inmates.
Exactly. So the court was quite aghast that the Federal Bureau of Prisons was making this assertion that they just didn't have access to this technology that basically every other teenager in the country had.
Yeah. Also question what the expectation of privacy is of prisoners at lunchtime in the place where they are required to eat lunch.
Right, which is exactly what the court said. It's like they're supposed to be here, so there's really no invasion of privacy, and even if there is, you really should be able to blur them out, or at the very least, you have to provide more information as to why this technology is beyond you in order for us to uphold your objection to providing this video. Additionally, the prison said they didn't want to provide the video because they were fearful that it would show the inmates where the cameras were, or if there were any dead spots in the prison lunchroom. The court again was by none of this, because in their initial answer to this, of saying that it might provide this information, they didn't actually, the prison did not actually state that the cameras were hidden, or that there were any dead spots in the lunch area.
That's pretty brazen when you think about it. So the idea is, I mean, the whole point of FOIA is to have kind of maximum access to public records with limited exceptions. And here the government is saying, like, well, it's possible that this may fall into an exception, without feeling the need to prove that it falls into an exception.
Exactly. That's what the court took issue with. And they basically told the government, look, the burden is on you to prove that this information falls under an exception. You have to provide more information than just conclusory statements that this could possibly lead to this information being, or get out to other members of other inmates at the correctional facility, and they may use that information for breaking activities.
Mm-hmm. All right. Well, so a victory for the plaintiff in this case, at least on collecting this information, and I'm sure at some point we'll see a further decision about how that affects his chances on the merits of his challenge. So now, why don't we jump over to the Sixth Circuit, where someone mouthed off to a cop and the cop did not appreciate that.
That's right. This case is called House versus Hodis, and it's, as Paul said, a Sixth Circuit case involving some Cleveland plainclothes cops who approached a man while he was entering his home and ended up getting into a fight with him because he had a smart mouth, which resulted in him getting beaten up on his porch in front of his own mother. Immediately after that, he was charged with the various contempt of cop charges. In this case, it was assaulting the officers and obstruction of official business, which I think is an Ohio special type claim that you can charge someone with. Eventually, those charges were dismissed, and House brought the civil rights action against the officers for excessive force and malicious prosecution. And the first thing to point out is that this is a case before the Sixth Circuit on a summary judgment, which means that all the facts are supposed to be viewed in the light most favorable to the plaintiff. So if the plaintiff and the cops disagree about something, the court is supposed to assume that what the plaintiff said is true and what the cop said is false. But for some reason, the Sixth Circuit's factual description includes just as much of the cop side of the story as it does of the plaintiff's. But then at the end, in a paragraph that's in parentheses, it says, yeah, but we're supposed to consider things from the plaintiff's side, so we're going to do that, but we just included the rest of this stuff for the sake of completeness. So then it dives into the QI analysis, qualified immunity, and then like Paul said earlier, they can skip to the second piece of the equation, which is whether law was clearly established without having to decide whether there was a constitutional violation. And so that's what the two judges on this panel decided to do. And they ended up saying that there was no clearly established case that what these officers did was sufficient to bring a false arrest charge under the Fourth Amendment. But really, the interesting piece of this case is that they announced in the Sixth Circuit that for malicious prosecution claims, the Sixth Circuit looks at the Fourth Amendment analysis, not a due process analysis. And what that means is when looking at a malicious prosecution case, what they're really looking for is what they called unreasonable prosecutorial seizure. And so that means that if there's probable cause for any charge, the Sixth Circuit now says you can't bring a malicious prosecution claim. And they even went on to say in a footnote that that means that if you're arrested for some reason that there ends up being probable cause, even if an officer didn't know there was probable cause, that's sufficient, and it would cover the officer even if the officer made up a bunch of meritless charges to pin on you. So that makes it stand out. There's also a dissent here from Chief Judge Cole where he points out that the panel majority definitely didn't consider the facts in the light most favorable to the plaintiff, and that there was no probable cause for the arrest, which he points out if there were probable cause, these cops would have charged this guy with an actual crime instead of just the crimes of resisting the arrest. For what probable cause, no one seems to know because there was no underlying charge that they were arresting him for.
So this is a pretty remarkable ruling. I mean, we were discussing earlier the problem of overcharging people, and as a result, this leads to very coercive plea bargaining. And here, if you combine the danger of overcharging with apparently this free pass to make up charges as long as one of them is justified, you can really strong arm people into taking just about any plea you put before them.
Oh, absolutely. So the panel majority does try to have some sort of escape valve where they say, well, you might be able to bring a malicious prosecution charge if the charges you're charged with that are meritless ultimately have a much longer sentence that might be assessed against you. But that's not this case, and we're not going to deal with that. And so it's good enough if there's any probable cause that can be decided after the fact by a judge for any charge, then you can't bring a malicious prosecution claim, which is kind of, is totally out of step with the general common law understanding of what a malicious prosecution claim would be. I mean, you can bring a malicious prosecution tort claim against a private actor, and usually the issue is just, whether they have done something to make you be prosecuted for something without a good reason for it. And here the Sixth Circuit is essentially saying, yeah, you can intentionally make up meritless charges as long as there's a charge, because all we're looking at is whether there was a constitutional basis for an arrest. And if there's any probable cause, they can arrest you and they can pretty much do whatever as far as the charging documents are concerned.
And that escape valve really isn't much of an escape valve because they've said, well, it's possible that blah, blah, blah. And that's not a clearly established statement of law. So in the future, if someone does pile up the fake charges that carry a much longer sentence. The Sixth Circuit will point to this and say, look, we said it was possible, but we hardly said that it was a guaranteed thing.
Absolutely. Yeah. And this could even be one of those situations where you'd say, look, not only did they say it was merely possible, they allowed it to, at least theoretically, to happen in that case. And so why shouldn't it be allowed to happen in this case? And even if it isn't, it's not clearly established, so we're not liable this time. So the best case scenario would be the next time this happens, the court might be able to clearly establish a new rule. But now officers in Ohio, Michigan, and Kentucky can kind of do whatever they want as far as getting back at people who show them an inappropriate amount of respect, which was what happened here.
Well, so I think that just goes to show how important it is that the Supreme Court eventually take up and reconsider this doctrine of qualified immunity. And if it's not in the Jessup case or in our case, maybe it'll be in one of these cases. Well, that's going to do it for us this week. Thank you all for joining us on this special socially distanced edition of Short Circuit. This is Paul Sherman at the Institute for Justice, urging you to stay safe, stay hygienic, and stay engaged.